Yes, Assalamualaikum. First of all, thank you for the introduction, and let me begin by saying that it's a real privilege and an honor to speak to you on partnership law. I am more of an academic as far as commercial matters are concerned rather than being a practitioner. As far as my practice area is concerned, that is public international law, but I teach business law and commercial law at the business school at LUMS, which is why I think it makes sense for me to speak about partnership law with you. So what I've done is that I'm going to take you quickly through a presentation on partnership law. Think of it as a quick, breezy sort of a reminder of what you probably already know about. But given this overload of material and information that you're subjected to every day, sometimes we tend to miss the very obvious and the very basic concepts. And before I get to, of course, partnership law, I just want to spend a minute or two to talk about why we're actually here and why it's so important for us to be doing what we are doing. So, one of the perennial problems that Pakistan has is that it hasn't been able to attract investment, foreign investment. Even domestic investors shy away from investing in the country. And one of the eternal complaints which the investors, the business community in Pakistan has, is that our judicial system can perhaps be extremely slow, and sometimes it can be unpredictable. So to address this long-standing complaint, this is really going to be one of the defining response to that challenge. It's not going to happen overnight, but we've got to start from somewhere, which is why I think all of you should also feel as if you're truly part of a chosen group, which is going to lead to great things for Pakistan, which is what we as a nation need at this critical point. Now, I'm sure there will be lecturers here who'll come and who'll keep on emphasizing that justice delayed is justice denied. But there's obviously a counter maxim to that, which is that justice hurried is justice buried, right? So what you have to do is in the final analysis, is to provide justice in whatever matter comes before you. Yes, you should try to be as efficient as you possibly can be, but swiftness, speed should not come at the cost of miscarriage of justice. I think that's an extremely, extremely important element of the entire judicial system. So that's the overriding value. So find that balance of being as efficient as possible. And one of the goals of this program is to improve that efficiency by, again, taking you through these refresher sort of sessions where many of these concepts, which must have been second nature to you, perhaps because of this, because of this overwhelming barrage of information, you've lost touch with. So with that, let me just come to the partnership presentation. But I'd also like to thank everybody who's been involved in this initiative, beginning from, of course, the Honorable Chief Justice of the Supreme Court, as well as the Honorable Chief Justice of the Lahore High Court, and all the various Honorable Justices who have been personally involved in steering this program and making it possible. Of course, I must also thank the Punjab government, the Ease of Doing Business unit that they have. The World Bank was also instrumental in designing this in the beginning. I was also involved in designing this program last year. So this is the second batch that we have. But last year when we did it, we didn't have the ordinance which we now have. So we're in a much more predictable space than we were last year. So, that's basically what I wanted to say in the beginning. Now let's begin with partnership law, and through this presentation, some challenges, some issues, some cases that can possibly come before you would also be addressed. Now, because I only have about 40 minutes to speak on the topic, it's not possible to holistically cover the law of partnerships and all the issues and challenges that come with it in 40 minutes. I mean, that's an impossibility. So don't treat this as the entire comprehensive presentation on partnership law. This is just, again, as I said, going to focus on the main primary issues that crop up, but obviously you're all, mashallah, intelligent enough and studious enough to then go back and familiarize yourself further with the statute, with the case law which is relevant. And one more thing which I want to say, it's a general point. It's important as far as the case law is concerned. It's important. Sometimes it happens that we don't really engage with technology as much as we should, because in the United States it's very easy to tell whether a case is still good law or not, or whether it has been overturned. Here sometimes from the lower courts, and this is a complaint which the higher courts have, which is to say that there's reliance on cases which have been overturned. So I think that's one of the things that you should be, it should be on your checklist. Always make sure that you're relying on cases which are still good law, which have not been overturned. That's important. That can really speed up the entire process without compromising on judicial values. Now, what are some of the primary issues? Now we're starting our journey in the next 40 minutes as far as partnership law is concerned. Now, why do people enter into partnerships? I mean, does anybody want to address that question? I mean, is it a form of business organization? Yes, it's basically a form of business organization. There are other forms of business organization also, such as companies, sole proprietorship, right? All of them have their own advantages and disadvantages. So you also have to understand the mindset of the business community, of the business persons who bring their cases before you. So knowing the law is one thing, but equally important is to understand where they're coming from. What is important to them? Why is time so important to them? Right? That's extremely important. So the reason why partnership law is important is because it is one of the more popular forms of legally organizing business. But it is not the only form, and even within partnerships there can be different types of partnerships. Now, in foreign jurisdictions such as the United States, there are still more forms of business organizations than what we find in Pakistan. But of course, we have the basic ones, which is sole proprietorship, partnership, and then companies. And as I said, one of the first critical choices which a business person has to make, or an entrepreneur has to make when he or she is beginning or starting their business, is to decide on an appropriate form of business organization given his or her business plans and ambitions. And as I said, companies would have certain advantages which partnerships would not have. Partnerships would have certain advantages which companies would not have. So all of them, you can compare and contrast them. So sometimes it's a difficult decision. But in Pakistan, you'll find many small, medium businesses registered as partnerships. You won't find foreigners getting into partnerships in Pakistan. When foreigners want to organize business in Pakistan, what do you think they prefer? Yes, companies, JVs, companies, mostly companies, right? And they have to get some exemptions, some permissions as well, right? So this is not really as relevant when it comes to foreigners as some other forms of business organization are. But nevertheless, we have domestic businesses all over Punjab, which are registered as partnerships. And also, we have services firms, lawyers firms registered as partnerships, operating as partnerships, right? So that's why what we're trying to engage with in the next half an hour or so is important. So what are some of the areas that I'm going to touch upon? Concepts कह लें आप इनको, areas कह लें, issues कह लें. They all kind of meet somewhere. So first of all, of course, I'm going to very briefly talk about the legal regime, some definitions, and then what are the essential elements of a partnership, what is a partnership deed, then this idea of mutual agency which underpins partnership law, and then what is the test of partnership. One of the cases that you will regularly face is that you will have to determine in a particular situation whether a partnership exists in that situation or not. So then you'll have to know, you'll have to apply that test whereby all the elements of partnership should be present, and then you have to look at all the facts and then determine whether in that particular situation partnership exists or not, right? And then, types of partnership. Partnership at will. Partnership at will is a partnership which has no duration, but at the same time, if one partner wants to leave, then the entire partnership can be dissolved. So, as far as continuity is concerned, partnership is not as advantageous as companies are. Companies have a perpetual life. They keep on changing ownership, but they don't get dissolved. Whereas partnerships are much more fragile when it comes to that. So that might be a disadvantage, right? So in some of the cases, it could be critical whether a partnership can continue or not, because some partners would perhaps be pushing for a partnership to continue while others would not want it to continue. But that can have enormous implications for the business, right? So anyway, partnership at will, and then there are particular partnerships. These are partnerships that are formed for specific, ventures, specific purposes, and they usually have a duration. So this partnership is formed for a period of 2 years. So upon expiration of 2 years, it will automatically get dissolved, right? Then types of partners, the sleeping partner, dormant partner, who's an ostensible partner, all of these terms, you need to know these terms. Then general and qualified duties of a partner. What are the rights of a partner is another important issue. And then partnership property. How do we treat partnership property as? Authority of partners. Partnership liabilities, including this notion that liability is limited or unlimited in partnerships. Is it unlimited or is it limited? What do you think? Yeah, limited. So we'll come to that. See, that's one form of partnership. But most partnerships are not limited. There are very few limited partnerships, limited liability partnerships, LLPs जिनको कहते हैं जी, वो भी आप कर सकते हैं. ये भी business persons की choice होएगी कि do they want to go for a limited liability partnership or do they want to go for a traditional partnership. Most partnerships in Pakistan, I would say 99% of partnerships in Pakistan have liability which is unlimited. Even personally, the partner's personal assets can be used to satisfy the debts which and the obligations which the partnership owes to third parties and the creditors. Okay? Alright. So we'll cover a little bit of that, partnership liabilities. And then in the end, of course, quickly talk about dissolution of partnership and firm. Legal regime and definitions. Now, what is the source of partnership law in Pakistan? Yeah, it's there. Partnership Act. Now in Punjab, there's also rules, Punjab Partnership Registration of Firms rules. Right? So within the jurisdiction of Punjab, these are also relevant. Other provinces also have their version of rules. Okay? And then, as you rightly mentioned, recently there was a Limited Liability Partnership Act. So limited liability partnerships are very few and far between right now. Okay? And they're somewhere between a partnership and a company. I mean, that's perhaps a good conceptual way of looking at them. So in a limited liability partnership, partner's liability is not unlimited. But of course, there are different rules for limited liability partnerships, how they can be created, for instance. Right? So, limited liability partnership agreement has to be registered mandatorily. That's not true for traditional partnerships. So there are important differences. But in the real world, 99% of cases that you will deal with will not be about limited liability partnerships. That is why after this slide, all our focus is going to be on traditional partnerships. Okay? But if you're interested in knowing more about limited liability partnerships, you can always go and and find out more about it. You should actually go and find out more about it. And then of course there are limited liability partnership rules that have been enacted under that act as well in 2018. So how partnership is the relation between persons. What do we mean by persons? Can only natural persons? Yeah, legal persons, right? So a company can be a partner, right? Because a company has a legal personality. Do partnerships have a legal personality of their own or no? No, good, they don't. They don't. Very good. So partnership is a relation between persons who have agreed. So this word agreed is very important, because essentially partnership at the end of the day is a contractual agreement. So when you're approaching partnership law, you can't do it without also relying on contract law as well as agency, law of agency. Only then can you properly assess partnership law. So this word agreed is very important. So persons who have agreed to share the profits, these are for-profit entities. Charities can't be partnerships. We're not interested in that. They have their own legal regime. You know that, right? Now, sharing of profits is essential. What about sharing of losses? Is it essential to share losses also or no? Okay, so well, in that situation what you're saying is correct. जी, आपकी बात भी ठीक है. But you can imply that if there is sharing of profits, then by implication there is sharing of losses also.
What was the intention of legislation by non-incorporating loss?
Well, I think the important trait or the element is about wanting to share profits rather than losses. I mean, you don't get into a partnership because you want to share losses, but your aim always is to make profit and then share that profit, right? So that's why there is that omission. But as I said, by implication, if there is sharing of profits, sharing of losses, these ratios can differ, right? So two partners can share losses and profits in different ratios. But if the ratios are not mentioned, are not specifically agreed, then equal. Then the default rule is equal, right? Equal sharing of profits and then equal sharing of losses. Yeah, it's true. You're right. I agree. That's why I said that you can imply it from this element that if there is sharing of profits, then there should be sharing of losses as well. But it's not an element, as you're rightly pointing out.
All these clauses, all these details are part of the contractual obligation. How much the investment, how
Hoga.
much the
Any good partnership deed will address this very specifically. But interesting cases are those which are outliers. So we want to understand it, the idea is fully, so that अगर जो outlier cases आएंगे वो भी आपके लिए challenge ना हो. That's the idea, right? In 99% of the times you will have a well drafted registered partnership deed which will talk about all of these things in detail, and as long as they are not contrary to law, those terms are fine, and you have to give effect basically to those terms, right? Partners and firm, persons who have entered, share the profits of a business carried on by all or any of them acting for all. What do you think this means? Agents. This means that partners are agents of each other and of the partnership. So law of agency is critical to partnership, right? Partners and firm persons who have entered into partnership with one another are individually called partners and collectively a firm, and the name under which their business is carried on is called the firm name. Okay. Now, essential elements of a partnership from that definition. 5, which you should remember, that it's an association of 2 or more persons. So there can't be a partnership with just one person, right? That would be void ab initio. So you need a minimum of 2. What about the maximum? 20. What about partnerships, where there are banks involved? Does the number change in that case? In that case, we have an exception, 10. We lower it to 10. But other than that, any other legal business, of course, it goes without saying that you cannot have a partnership for an illegal purpose. Just like you can't have a contract for an illegal purpose, that would be void. Similarly, you can't have partnership for illegal purpose either. But for any lawful purpose, as long as the objective is for profit,
Is it correct that the relationship between the see the partner throughout is as contractual of the
sorry, repeat जरा करें अपना सवाल.
Is it correct that intercede the part of contractual relationship not exist?
Individual contractual relationship doesn't.
Intercede the partner.
That's true, because they are basically, once there is a deed, it's a collective agreement between the partners, not an individual.
You mean to say that there exists contractual relationship between them?
No, they are in a partnership relationship, right? But that partnership relationship, the basis of the partnership relationship is contractual. You understand? Yeah, that's contractual, because the partnership deed is basically a contract. It's an agreement, right?
They judgment of the Supreme Court of Pakistan, quoted as 1991 SCMR 2324, wherein it was held by the Honorable Supreme Court of Pakistan that in case of contractual relationship, no suits for rendition of account can be filed. But in case of partnership, the suits for rendition of account can be filed.
ठीक है.
Because there is no contractual relationship between the partners.
हाँ, वो ठीक बात है. That's true. The partnership itself is the product of a contract or an agreement. इसका लेकिन तो उसके बाद जो rights और duties और obligation partners की होंगी, वो उस partnership deed के अंडर होंगी, right? So partnership deed versus an ordinary contract, they're very similar though, okay? But as a term of art, इसको कहते हैं term of art, आप distinguish कर सकते हैं अगर आपने बाल का खाल निकालनी है, right? But that case is an interesting one. Maybe all of you should go back. आप अपने साथियों से भी share करें कौन सा case है, so that you can find further clarity in terms of what the हाँ ये ठीक है. हाँ ये ठीक है. I mean there's a bit of back and forth on this, right? It's always good अगर आपने partnership deed को register कराया है, right? Because then that's a prima facie evidence of the existence of a partnership. That is not correct, okay? LLPs के अंदर आपको register कराना ज़रूरी है. Traditional partnerships, I mean ordinary partnerships, good practice makes it very easy अगर आपने register कराया है, properly register कराया है. Registration का भी अपना process है, right? It has to be notarized and so on and so forth. वो सारा ठीक, exactly. अच्छा जी, definition of partnership, 5 essential elements which you should always keep in the back of your minds. Association of 2 or more persons, हमने cap भी discuss कर लिए, 20 तक जा सकते हैं. And then there has to be an agreement, right, which is called the partnership deed. Then carrying on business, sharing of profits, and then this mutual agency. Partnership deed. A partnership is a contractual agreement between the partners. This agreement may be express, whether written or oral or implied. This is all theoretically possible. The written agreement is known as partnership deed. In Pakistan, partnership arises from contract and not from legal status. Okay. Partnership deed is not required to be registered under the law, but it is preferable to do so. If the partnership agreement does not specify the rights or duties of the partners, agar partnership agreement, the partners are free to choose whatever terms they want, pretty much whatever terms they want, as long as it's not against the law. But in those areas where they have failed to agree to any terms or the partnership deed is silent, then the default rules are the ones which are provided in the Partnership Act. So Partnership Act का क्या एक function है, major function क्या है? It has this gap filling function that it fulfills in those cases where the agreement is otherwise silent. Now, if a partnership exists but does not have a written agreement, it will be presumed that the rules of the partnership agreement are those contained in the Partnership Act. This is what I said earlier. Partnership deed. Partnership deed में usually आपको क्या मिलेंगी चीजें? इससे ज़्यादा भी हो सकती हैं, कम भी हो सकती हैं. Every deed is going to be different. Obviously, if you engage good lawyers who are better draftsmen, then you'll have a well-drafted, well-created partnership deed. Yeah? But anyway, at a minimum, you'll have firm name, place or principal place of business of the firm. जब आप firm name choose कर रहे होते हैं, वहाँ पे trade names, trademarks, that can be relevant. So intellectual property is also relevant, right? And then place of principal, place of business of the firm, names of any other places where the firm carries on business, the date when each partner joined the firm. ठीक है. Can new partners join the partnership after a partnership comes into existence? Is it possible? नए partners add किए जा सकते हैं बाद में? हाँ. Yes, through mutual consent of the existing partners. Because every partner has the right to choose whether to admit a new partner or not. Ordinary जो matters होते हैं partnership के, उसमें आपको majority की basis पे decisions होती हैं. So if it's a 5-person partnership, 3-2. But there are some extraordinary matters where you require unanimity. And one of those extraordinary matters is admission of new partners. Because उससे, if you admit new partners, then that whole scheme of profit, loss sharing, liabilities, it changes. Okay, names and full and permanent address of partners, duration of partnership. If you're going for a particular partnership, then you'll specify the duration also. Partnership at will के अंदर duration नहीं होती. Purpose of the partnership, rights and duties of the partners, amount of capital that each partner should put into the business and keep in the business until the partner retires or the partnership is dissolved. Okay? Mutual agency. A mutual agency relationship exists among partners, which means that each partner is both an agent and a principal. Each partner is an agent in the sense that he has the capacity to bind other partners by his acts. If I am entering into a contract on behalf of the partnership, what does this mean? This means that I am binding my co-partners as well. That's the agency triangle. That means they're also now exposed to liabilities because of my actions. That's why it's important to understand this idea, this notion of mutual agency, which is critical to to partnership law. Each partner is an agent in the sense that he has the capacity to bind other partners by his act. Each partner is principal in the sense that he is bound by the acts of the partners. So आप bind भी कर सकते हैं और खुद भी आप bound हो सकते हैं through acts of other co-partners. So you are an agent, you are wearing the hat of an agent, but you're also wearing the hat of a principal. A partnership, unlike a company, does not have a legal personality. ये हमने discuss कर लिया. Important. A third party entering into business transaction with the partnership does not have a contractual agreement with the partnership. The contractual agreement is between the third party and all the partners as individuals. Because उसकी अपनी personality नहीं है, that's why you have to have this scheme.